Announcements prior to getting started. We are video conferencing this to our regional offices, so since we have the bulk of everyone in Philadelphia, if you could just open chips or soda cans prior to getting started, this way it could eliminate some distractions on the video conference. You know, the very important stuff. But welcome. I am going to hand it over to Professor Chanenson, and then we'll get started.
Well, thank you very much, Maria. We really appreciate it. Thank you very much to our friends at Cozen O'Connor for hosting us here today. My name is Steve Chanenson. I'm a professor at Villanova Law School, as well as the faculty director of the David F. and Constance B. Gerard DiCarlo Center for Ethics, Integrity, and Compliance. I have the easy job today. My job is to introduce the experts sitting to my left and help keep the train running on time over the next 2 hours. We'll be talking today about issues of harassment and discrimination and their interaction with the rules, primarily focusing on new ADA Model Rule 8.4G, its proposed adoption here in Pennsylvania. And I think you will be very pleased by the time we're done with having the perspective of the four distinguished individuals to my left. So I won't belabor the point. Let me do brief introductions. To my immediate left is my colleague, Doris Brogan, also a professor at Villanova University's Charles Widger School of Law. Professor Brogan is a graduate of Rowan University and Villanova University, Charles Widger School of Law. Doris is a scholar and teacher of professional responsibility and also a longtime administrator and former dean of the law school. To her left is Jennifer Coatsworth. She's an associate at Margolis Edelstein, graduate of the University of Maryland Honors Program and Temple University Beasley School of Law. Jen is very involved in the Philadelphia bar community, the assistant secretary of the Philadelphia Bar, currently running for re-election. Also the co-chair of the Women in the Profession section of the Philly Bar, treasurer of the Women in the Profession section of the Pennsylvania Bar, vice chair of the Civil Litigation section of the Pennsylvania Bar, and just in case you thought she slept at some point, she's the incoming chancellor of the Brandeis Law Society. To her left is Tom Wilkinson, a member here at Cozen O'Connor, and thank you as well for hosting us. A graduate of the University of New Hampshire and the Villanova University Charles Widger School of Law. Same year as Professor Brogan. There was something very ethical in the water that year, I think. Tom is the former president of the Pennsylvania Bar, former president of the Pennsylvania Bar Institute, and an author and frequent speaker and expert on issues of legal ethics. And rounding out the squad all the way to the left is Josh Blackman, an associate professor of law at South Texas College of Law in Houston. If some team other than the Cubs had to win the World Series, I'm glad it was you guys.
I'm a Yankees fan, I got nothing.
All right, good. Wow, here it was. I was saying something nice for the American League, and look what it gets me. Professor Blackman is a graduate of Penn State University and George Mason.
And a clerk in the Western District of Pennsylvania.
See, so you're really coming home here to the Commonwealth. He is a prolific author on a wide array of topics, works also with the Cato Institute, and among my favorite of his activities is he's the founder of Fantasy SCOTUS. If you couldn't be more engaged and geeky about the law, then this is the way to do it, and it's a lot of fun. So we have a variety of perspectives here today on this topic of the way in which the rules should address questions of harassment. And with that, I will be quiet and turn to Professor Brogan.
And I'm going to stand at the lectern because that's what law professors do. Some of us. Some of us. I just like to be able to see you all and figure out if there's somebody in here I can call on. So good afternoon.
Afternoon.
Good afternoon.
Good afternoon.
You're awake for the moment.
You're awake.
It's yours to lose.
So it's my job this afternoon. My job, Steve said his job was easy. My job is pretty easy too, until we get into the more controversial, more contentious part of the discussion. What we're here to discuss this afternoon is race, religion, ethnicity, and disability. Bad idea that you all have food, because everybody knows these are topics that you don't want discussed at a dinner table or where people have food to propel and get into a food fight. But they are topics that are crucial for lawyers to discuss, and to discuss responsibly, thoughtfully, respectfully, courageously, to get into the discussion of how we comport ourselves as lawyers and whether or not we need to be told how to comport ourselves as lawyers. So the question up for grabs today is whether or not the Pennsylvania Supreme Court should amend the rules of professional responsibility that govern lawyers and declare more explicitly that lawyers may not engage in discrimination or harassment based on sex, race, gender identity, ethnicity, religion, or disability. Hard questions, but I'm confident we're up to the challenge. So let's begin with a little bit of history. At the annual meeting of the ABA in August 2016, the House of Delegates approved a resolution that revised Model Rule of Professional Conduct 8.4 to add specific language in the rule prohibiting expressed forms of discrimination and harassment. That resolution is in your materials right at the beginning, as are additional comments that are designed to explain the rule and its approach and what it's intended to do. The Standing Committee on Ethics and Professional Responsibility took the lead on bringing this forward, but they did it in conjunction with 5 or 6 other task force and sections of the ABA. According to the report accompanying the proposal, the new amendment to the rules continues initiatives begun by the ABA 35 years ago. At least as early as 1983, when the ABA reformulated its own objectives and mission statement, organizing them under 4 major goals. Goal number 3 of those 4 goals was it charged the association to eliminate bias and enhance diversity, and specified 2 objectives under that goal. 1, to promote equal participation in the association, our profession, and the justice system by all persons, and 2, to eliminate bias in the legal profession and the justice system. Coincidentally, 1983 was the year the rules were advanced by the ABA to replace the old Code of Professional Responsibility with its Byzantine tiered levels of canons, ethical considerations, and DRs. Who remembers the DRs? Steve Ford, get your hand up. Ethical considerations, DRs, the ethical considerations modified the DRs, but they weren't rules, there were comments, it was a mess. So the model rules replaced them. Model rules with comments. It was also the year I began teaching Villanova's ethics course. At this point in 1983, some states had begun addressing concerns with bias in the system. The problem gained more systemic attention in the early 90s. At that point, most of the state judicial systems and 9 of the 12 federal circuits established formal task forces charged to explore bias in the legal system. Most of the task forces focused on gender, but 5 circuits, including our 3rd circuit, undertook examination of race, gender, ethnic, and religious bias in the entire system. These studies pointed to reliable evidence that bias existed at all levels, across the spectrum. That is, not only with respect to lawyers, but as important, with respect to litigants, with respect to staff, and with respect to others who came into contact with the system. The bias ranged from the almost implausibly outrageous. For example, one New York lawyer, on the record, in a deposition, made vulgar references to his opposing counsel, a woman, describing her with a pejorative word used to describe a part of the female anatomy, or a judge, also on the record, responding to a woman who asked if she too could take her jacket off as had her male counterpart, and the judge replied, not unless you take off all your clothes as well. The less extreme cases involve calling women by their first name while referring to men as Mr., referring to women as sweetie, honey, darling, and dear. And as Marcia Stern pointed out in a 1966 article, the impact of bias extended beyond the courtroom and the deposition and the formal activities that lawyers undertook. It took its toll in settlement conferences and in negotiations and consultations that happened informally. Stern points out that non-courtroom instances of bias are often of greater importance because of the significance of the work being done and the fact that those activities represent the greatest portion of most lawyers' working lives. Most of the instances recounted in the law review articles and the commentaries, most of the anecdotes seem to involve women. And in part, again, that's because many of these studies were undertaken with a focus on gender. But as Judge Dolores Sloviter observed in her introduction to the published report of the Third Circuit Task Force on Equal Treatment in the Courts, it is evident that task forces focusing exclusively on gender bias were overlooking other large discrete groups that have frequent contact with the federal courts, but less frequent participation within the system itself. And she named particularly African Americans and Hispanics. At the same time as these forces were coming together, the ABA the Standing Committee on Ethics and Professional Responsibility began work on a model rule that would address discrimination head-on. Thus, it has indeed been a long, strange trip. The ABA has been wrestling with this problem almost as long as I've been practicing law, and that's a long time. Some states did act early, directly including in their rules language identifying discrimination and harassment as sanctionable, actionable conduct. But other disciplinary authorities were finding authority to sanction bias and discrimination in the language of the existing rules. So if we look at Rule DR 1102, the old DRs, Paragraph 5 uses the language that it is misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice. Some disciplinary boards use this language to sanction sexual harassment and discriminatory behavior. The case of the lawyer I mentioned earlier, the New York lawyer who referred so colorfully to his female opponent, was eventually brought up before the New York court and the New York Disciplinary Authority. The court, in affirming sanctions, found that his conduct was unduly intimidating and abusive toward counsel, and that he directed vulgar, obscene, and sexist epithets toward her anatomy and gender. That thus he had violated DR 1102, paragraph 5. The court noted his conduct, which had occurred several times recently, within weeks of his being brought up before the court, was inexcusable, intolerable, and prejudicial to the administration of justice. Pretty bad. The court was so outraged that it publicly sanctioned him. Rule 8.4, the current misconduct rule, was adopted in 1983, and it carried virtually the same language forward. And again, some districts did rely on this language to sanction and take action with respect to certain kinds of discrimination. But as I said, by the 1990s, a number of states had adopted their own rules. For example, New Jersey has its own Rule 8.4. It is professional misconduct for a lawyer to engage in a professional capacity in conduct involving discrimination because of race, color, religion, age, sex, sexual orientation, where that conduct is intended or likely to cause harm. Florida had a similar rule. But the ABA did not itself gain the support necessary to adopt the non-discrimination language as part of its formal rule. However, in 2007, the ABA did have the momentum to adopt Rule 2.3 of the Model Code of Judicial Conduct, which prohibits judges from engaging in conduct manifesting bias, prejudice, or harassment, and provides that a judge must assure that lawyers appearing before her refrain from such conduct as well. The rule does contain the usual provision insulating legitimate advocacy and protecting lawyers' autonomy to select clients. Nonetheless, efforts to add specific non-discrimination, non-harassment language to the ABA model rules for lawyers stalled. They never gained momentum. The old version of the ABA rule reads, includes that paragraph that says conduct that is prejudicial to the administration of justice. And again, this is the rule that has been in force, dubbed the misconduct rule. It identifies broad stroke bad conduct. For example, violating the rules of professional conduct is misconduct. Surprise. As is committing a crime, but only if that crime reflects on the lawyer's honesty, trustworthiness, and fitness as a lawyer. But as we saw with DR 1102, 8.4D has the prejudicial to the administration of justice language. And many jurisdictions did rely on this language to sanction discriminatory behavior. But enforcement was spotty, with many courts and disciplinary boards interpreting the language as not supporting such charges. So in 1998, a proposal was brought forward to amend 8.4 to add explicit language defining discrimination, harassment, and bias as misconduct. Sponsors soon realized that the House of Delegates was not in a position to approve amending the rule, but they might support amending the comments to make it clear that a lawyer's words and conduct manifesting bias or prejudice violated 8.4, and that they are prejudicial to the administration of justice. This language was added to Model Rule 8.4's comments. Pennsylvania is among a handful of states that neither amended its rules to explicitly define bias, discrimination, and harassment as misconduct, nor did Pennsylvania include comment number 3 that is designed to explain that the ABA considered that to be misconduct. The problem with leaving the provision with respect to discrimination in a comment is explained by the rules themselves. In paragraph 21 of the preamble and scope of the section of the model rules, quote, the comments accompanying each rule explain and illustrate the meaning and purpose of the rule. The comments are intended as guides to interpretation, but the text of each rule is authoritative. So to the extent the ABA was relying on the comment, jurisdictions that said, we still don't think the language supports it, well, you have the comment. The comment is designed, as the rules themselves say, only to illustrate the meaning. So it gave many jurisdictions pause. They didn't feel comfortable in prosecuting discrimination under the rule, using simply the comment as authority. Although the ABA was not ready to amend the black letter rule in 1998, by 2015, many states had already amended their own versions of the rules. Another 13 jurisdictions elected to address the issue in the comment that you see in comment number 3. And against this background and the continuing problem that was identified with discrimination within the profession, in August 2016, the ABA Standing Committee on Ethics, Professional Responsibility proposed the new Model Rule 8.4. And that includes the language that explicitly designates discrimination and harassment on the basis of race, religion, ethnicity, and gender and sexual identity as violating the rules. This brings us to our discussion today, and our next speaker, Jennifer Coatsworth, will discuss the recommendation of the Philadelphia Bar Association with respect to the question of whether or not the Pennsylvania Bar should adopt new Model Rule 8.4.
Just take the
You may.
So before I get into what the Philly Bar did, I want to just do a little bit more explanation about Rule 8.4G itself and what it means. So first, what is conduct related to the practice of law? It includes representing clients, interacting with witnesses, coworkers, court personnel, and lawyers and others while engaged in the practice of law, operating or managing a law firm or law practice, and participating other things that we may not think about, such as participating in bar association activities, business or social activities in connection with the practice of law. Professor Brogan already talked a lot about what 8.4G, what Model Rule 8.4 did, which was prohibit certain conduct. So 8.4G is sort of a natural genesis from that, in that it just added another element of conduct that would be prohibited pursuant to the rule. And as Professor Brogan also mentioned, comment 3 of 8.4 had already been in place since 1998. So again, this is sort of just a natural progression because, as Professor Brogan also mentioned, the comment is not a rule, and attempting to enforce a comment posed significant complications that was believed could be remedied if the comment was mutated into a rule itself. There were some substantive changes that were made in the model rule. The differences between former comment 3 and the new proposed 8.4G are intended to make it more concrete and easier for lawyers to follow. It substitutes the more specific phrase of harassment or discrimination for bias or prejudice, in accord with legal standards in many aspects of the law. It also eliminates knowingly manifests by word or conduct and uses clearer and stricter standard language. Standard engage in conduct that the lawyer knows or reasonably should know, which are specifically defined terms. Note that the Pennsylvania Bar and the Allegheny County Bar Association recommendations would not include reasonably should know, which I know Tom is going to discuss a little bit later in the presentation. It also adds to the pre-existing 8 prohibited bases: ethnicity, gender identity, and marital status, in accordance with more recent and modern developments in the law. How does it help the legal profession? Well, anybody that's in this room who is a member of any of the protected classes can certainly say for sure how this is going to help our legal profession. I can give an example from personal experience. Just about a week ago, I was in a deposition where I was the only female attorney, and not one but 2 of the other male attorneys referred to me as the court reporter. And that's just a very unegregious example of the type of conduct. And some of the examples that Professor Brogan mentioned are some of the definitely more severe examples, and they happen all the time. Second of all, we counsel our clients on this all the time, right? I mean, we counsel our clients that they have to conduct themselves in a certain way so as to avoid lawsuits and litigation. We need to hold ourselves to that same standard. It will only help our profession with its perception if we can do that. It also helps lawyers with clearer definitions of what the parameters of what is prohibited, even though some of the conduct is already prohibited. It also sets out guidelines and comments that protect the operation of law practice and the right of free speech, thought, association, or religious practice. And it also limits its application to conduct related to the practice of law. How does it affect law office operation and the selection of clients? I already talked a little bit about what conduct related to the practice of law is, but it includes representing clients and interacting with witnesses and other things that we don't necessarily always think of, such as bar association activities. Does it mean that we have to take every case that comes in? No. The rule would not limit the ability of a lawyer to accept decline or withdraw from a representation in accordance with current rules. And the PBA language, which Tom is going to comment on, also talks about the recommendation in the comment language. Does the rule affect legal fees? No. Discrimination against persons based on the source of income or based on their acceptance of free or low-cost legal services are examples of discrimination based on socioeconomic status. And comment 5 of the proposed model rule makes it clear that the rule would not limit a lawyer's ability to collect a reasonable fee and reimbursement of expenses, nor would it affect the lawyer's ability to limit the scope of his or her practice. 8.4G also does not limit advocacy. It does not, it's not already encompassed in the model rules and any other applicable laws and court rules. The new paragraph G would inhibit a lawyer's ability to represent a client or argue a position for the client. It does not prohibit legitimate advocacy or advice, and it is consistent with the other rules of professional conduct. And a trial judge's finding of peremptory challenges were exercised on a discriminatory basis does not alone establish violation of this rule. That's something that was raised a lot during the discussion in the ABA, as I understand it, and it does not establish a violation on its own. The new rule would also provide practice guidelines. Lawyers may engage in conduct undertaken to promote diversity and inclusion. And a lawyer may limit the scope or subject matter of the lawyer's practice, or may limit the practice to members of underserved populations. A trial judge's finding, as I said, of the peremptory challenges does not alone establish a violation of the rule, and it does not, as I also said, limit the ability of the lawyer to accept, decline, or withdraw from representation in accordance with Model Rule 1.16. Now, the Philadelphia's version of the resolution encouraging the Supreme Court to adopt this rule. Philadelphia, we like to sort of consider ourselves as a little bit more progressive than the rest of the state. So when the ABA resolution came down the pike in the summer of 2016, as the co-chair of the Women in the Profession Committee, the chancellor at the time came to me and said, I think we need to take a stand on this and do something in support of it. We in the Women in the Profession developed a resolution which was presented to the Philadelphia Bar Association Board of Governors. However, in connection with those negotiations to get that resolution passed, we also consulted with the Professional Ethics Committee of the Philadelphia Bar Association, and there was a very much debated meeting of that committee, and there were certainly some folks who espoused opposition to the resolution, but overall the general consensus of that group was very much in support of the resolution and of adopting the model, of encouraging the Supreme Court to adopt the model rule as promulgated by the ABA. And so ultimately on October 26th of 2016, we put forward that resolution to the Philadelphia Bar Board of Governors, and it was passed unanimously by the Board of Governors with very little conversation at that point. At that point, a lot of folks had already attended the professional responsibility meeting and were aware of the issues, and the resolution passed unanimously. And the Philadelphia Bar had also, this was consistent with the Philadelphia Bar's previous policies, which in 1997 recommended that sexual harassment be included as a form of professional misconduct under Rule 8.4, but that recommendation was not acted upon. And also in 1998, the Philadelphia Bar recommended that the model rule comment be added to Rule 8.4, but that recommendation was also not acted upon. The Philadelphia Bar does have a statement of diversity inclusion action plan and a statement of diversity inclusion principles, which this resolution was entirely consistent with, which was one of the reasons why it had such broad-based support by the Board of Governors.
Thanks, Jen. I just wanted to thank Steve and the Gerard Carlos Center for highlighting this important issue. It's probably the most important issue that's faced the ethics committees as far as ethics rule changes in the past 10 years. We're now moving on to looking at trying to streamline our advertising rule. That's the next big hump to jump over. But this is very important, of course, and the timing is quite interesting given the watershed developments that have recently occurred in Hollywood and in politics and in business circles. So it's not set up with that in mind, but it just coalesces at an interesting time. To provide a little more background on Doris's excellent summary on the ABA side, I was fortunate enough to be at the ABA annual meeting when the hearing was held by the Standing Committee on Ethics and testimony was taken on this rule. And there was a lot of sausage made during the process. It went back and forth. There were a lot of language changes and edits. Clearly, even shortly before the ABA House of Delegates meeting, there were last-minute changes that brought back a mens rea requirement. The mens rea requirement previously being mentioned in the model rule, which is knows or reasonably should know. For a time, it wasn't in there because some people, including academics and influential people within the ABA, like a former president, Laurel Bellows, who's a plaintiff's side employment lawyer, urged that there should be no knowing requirement. It should be basically strict liability if you commit harassment or discrimination. So for a while it was out, and some of us urged that it be placed back in so that there not be entirely negligent instances of harassment and discrimination for which lawyers could be disciplined. There were other minor changes made, and when it ultimately went through to the House, it was passed by an overwhelming margin. I was at that meeting. It was a very interesting change to the rules. And of course, then the process is that it's shopped out to the states. The ABA Center for Policy Implementation sends it to the Chief Justices of all the states or their bodies that implement rule changes. And then you hope that the states will review those changes and evaluate them through their processes. And Pennsylvania is a good microcosm of what happens in states. We have the Philadelphia Bar, we have the Allegheny County Bar, both issuing support for model rule change, and the ACBA with some edits. And then Pennsylvania Bar Association Legal Ethics and Professional Responsibility Committee also was heavily involved from the get-go on the ABA changes, followed them closely, and took into account the history, which was quite long within the PBA, I'll call it Pennsylvania Bar Association, the PBA, which went back to 1996, which then President Leslie Ann Miller, who some of you know, very active in the Philadelphia area, urged the Pennsylvania Supreme Court to adopt a policy prohibiting sexual harassment in the practice of law. 3 years later, in 1999, then PBA President Jim Mundy, the husband of our incoming or continuing Justice Sally Updike Mundy, urged that the prohibition be expanded to prohibit ethnicity and race discrimination in the practice of law. Those recommendations were not approved by the Supreme Court. In addition, as Doris mentioned, the comment 3 to Rule 8.4, which would have prohibited discrimination, overt discrimination, was not adopted by the Pennsylvania Supreme Court despite a recommendation along those lines. So we didn't have much of a track record, at least with the Supreme Court, in getting these changes adopted. You can read more about that in the materials that are included that are the background for the Pennsylvania Bar Resolution. The Pennsylvania Bar Resolution was a cooperative effort with the women profession, as well as the minority bar, and the professional liability committee. The professional liability committee consists primarily of lawyers who defend lawyer malpractice claims, and clearly they had a concern about disciplinary consequences and whether there'd be insurance coverage for these kinds of claims and so forth. We worked very hard with them, and one of the people who was right in the middle of that process was our Dan Harrington of Cozen O'Connor, who is the current chair of the Pennsylvania Bar's Legal Ethics and Professional Responsibility Committee. I dragged him into this process a few years ago. I was chair back in 93 to 2004. So he was in the forefront. He also presented the recommendation that was the joint recommendation of the women profession in the Legal Ethics Committee to our House of Delegates very successfully, along with my wife Kathleen Wilkinson, Jennifer, and others. And the House of Delegates approved it overwhelmingly with some tweaks. And the tweaks are, I can summarize fairly quickly for you, because obviously there are some people who are watching or listening who are not Pennsylvania Bar lawyers, and therefore may not be quite as interested in these specific tweaks, but there is a rhyme and reason and rationale behind them. In subpart G, we tethered the harassment and discrimination prohibition to those terms that are defined in applicable federal, state, or local law. So in other words, it wasn't clear, or as clear as it could be, whose definition of harassment and discrimination really would apply, and whether people may have differing personal views about what constitutes harassment and discrimination. We try to clarify that by tethering it to federal, state, or local law. And I know that Josh is going to want to talk about that because it was addressed in his article, which is also in the materials. We also tried to pin down a little more strictly the mens rea requirement under this rule. As I said, there was a flip-flop by the ABA during the process of first having a mens rea requirement, then dropping it entirely, then bringing it back in order to get more people to sign on, more groups within the ABA to sign on to the rule, because it looked like it was going to face very serious opposition in the House. And they managed to overcome that opposition by adding knows or reasonably should know as a prong for the mens rea requirement. We said, let's drop reasonably should know, because it just sounds just like negligence. There really should be a knowing instance of conduct or multiple instances of conduct for discipline to apply. Knows means under the rules, actual knowledge, which can sometimes be inferred from the circumstances. If it's very clearly obvious that the lawyer knows, a denial may not be sufficient to overcome that. So we tightened the mens rea requirement, and we think it's helpful and also provide better guidance, not just to lawyers, but also to the disciplinary authorities who are required to enforce the rule. We added a new comment sentence under comment 3 to state that this rule does not serve to expand upon or limit a claimant's available rights or remedies under the law governing harassment and discrimination. So what does this mean? What it means is that there were approaches and suggestions that there should be either some predicate statutory law violation having to be found before one could be disciplined, or that you had to perhaps process your complaint through a state or federal process and get some right to sue or be found to have a valid claim before you could pursue a disciplinary complaint. We wanted to make clear that the adoption of this rule does not change the available rights or remedies under federal or state law. You can, if you've been the subject of harassment or discrimination that's knowing in nature, you can file your disciplinary complaint and you can pursue it through the system. You can pursue your federal or state complaint, and they're not mutually exclusive. You can choose not to pursue your federal or state complaint, but only the disciplinary complaint, and you're not going to be prohibited or precluded from doing so. And the rationale for that, which I'm going to supplement once we talk about the disciplinary board's proposal, is that you shouldn't be required to go out into the state or federal court system, hire a lawyer, perhaps incur fees, perhaps wait 2 years or longer to play out that whole process in order to pursue a disciplinary complaint. Particularly if it's a situation where the harassment or discrimination is ongoing in nature, the disciplinary board, Office of Disciplinary Counsel, or the prosecutor should be able to investigate it and not be constrained by whatever might be happening in state or federal court. They can certainly exercise their discretion to hold off on pursuing the investigation or pursuing it to a hearing until the outcome of a state or federal court proceeding, but they're not obliged to. So this was a clarification that we thought was helpful. We didn't change the conduct relating to the practice of law, and as Jen mentioned, relating to the practice of law is not confined to the representation of clients. I know Josh is going to speak to this. I don't want to steal his thunder. And there are some concerns that are reasonable in this area, but it's clearly intended to apply to the situation where you're out entertaining clients, you're at a firm-sponsored event, you're at a bar association event with other lawyers, and some of those events, those of you who've been around for a long time, were bastions of problematic situations where people were preying on younger members of the bar. I'm not saying I ever saw it, but I've certainly heard about it. And situations where you may be at, say, a Phillies game or a related sporting event, and there's some harassment or discrimination in the course of that event, but it's clearly a firm-sponsored marketing or other kind of event. Just because it happens in that setting doesn't mean that the rule should not apply, was the rationale of the ABA, and the PBA and the other large bars in Pennsylvania agree with that approach. That shouldn't just, it shouldn't be left with no remedy through a disciplinary process if it occurs through a sanctioned event. Under comment 5, we also added a sentence to the following effect: this rule does not require a lawyer to accept or reject the representation of any prospective client who is a member of any of the reference classifications. What's that mean translated? It means that you're not required to accept a client, corporate or individual, with whom, for example, you may not agree with their personal views, and you may not agree with what they're trying to accomplish. You may not want to buy Masterpiece cakes from them. There are a lot of issues that arose, and because this rule came up in the same time frame, but in my view was entirely unrelated to the Masterpiece Bake Shop case. In fact, it was earlier than the Masterpiece Bake Shop case. There was concern among the religious right that it could present free speech issues, either in that area or preclude expressions of opinion about same-sex marriage. I don't think it was in any way intended to limit that kind of speech. There are people who have a different view, like Josh. I respect that view. Obviously there's a First Amendment right to express personal opinions, and those personal opinions shouldn't lead you in the normal course to disciplinary consequences. And we have to rely upon, and some people aren't happy to rely upon it, we have to rely upon the exercise of good discretion by our disciplinary authorities as to what cases do really reflect a First Amendment overlay and which cases don't, whether they're true harassment and discrimination. They cause some personal harm to the target of that harassment and discrimination. And it's not simply an expression of what might be deemed an unpopular or conservative or unusual or provocative political or other personal opinion. I think we have tried to ensure that lawyers retain that right and discretion to accept cases and matters and clients that they're comfortable with. And at the end of the day, they don't believe in the Masterpiece Bake Shop position, then they shouldn't take that entity as a client. They should decline it because they're not going to do a good job if they don't believe in the position taken by the client. So that's the those are the changes in summary form that the Pennsylvania Bar recommended. The recommendation was memorialized in December 2, 2016 letter, which is in your materials, under the signature of past President Sarah Austin of the Pennsylvania Bar. That letter was drafted by some combination of the Ethics Council for the Pennsylvania Bar, myself and Dan Harrington, and others, including members of the WHIP. We like the letter. I think it's a good letter. We hope the Supreme Court will take it up and act on it and approve it. The ACBA, the Allegheny County Bar, also supported it in that form, and we think those clarifications are useful.
And before Tom talks about the disciplinary board position, there was some discussion following the Pennsylvania Bar meeting as to whether or not the Philly Bar would alter their recommendation, their resolution, to be more in accord with the PBA recommendation. And ultimately it was decided that the Philly Bar did not want to do that because specifically the provision that Tom mentioned where the conduct is tethered to the local, state, and federal rules, the Philly Bar believed that because there are some instances with discrepancy between the local ordinances and the state and statewide legislation, they believed that because in many instances the municipal ordinances were a bit more inclusive, they did not want to be confined by tethering the conduct to what is defined in state statutes.
So the matter is now before the Supreme Court, but an interesting wrinkle developed, and I was going to mention this one slide. We do have a unified judicial system policy applying to judges and every staff member, and even those serving on Supreme Court boards and committees that prohibits, it's an anti-discrimination policy. There are other facets of this policy which we're not going to get into today because most of you don't serve in those capacities. In November, right around when the Pennsylvania Bar House of Delegates was meeting, the disciplinary board issued its own notice of proposed rulemaking, and it was like two ships passing in the night because they came out with what was a very conservative approach to this issue without waiting for, and despite the fact that they knew full well the Pennsylvania Bar was looking at the issue and about to make recommendations, they grabbed an old rule from Illinois, which had been adopted over 20 years ago, and said, well, this is an easy approach to the problem, let's make it go away. And that rule, which is here on your slide, in essence would require any complainant to fully exhaust their available administrative or statutory remedies before pursuing a disciplinary complaint, before the disciplinary board would even consider it. And that provide a lot of loophole kinds of problems. One of the loophole problems was that if that complaint was pursued and ultimately settled, there would really be no opportunity to pursue a disciplinary complaint. The excuse given in their notice of proposed rulemaking for this limitation was that their resources were strapped for purposes of enforcing the rules already, and therefore notwithstanding the fact that harassment or discrimination may be extreme in nature, we'll hope that it goes away, or we'll wait a couple of years to see whether you really have a claim that has been accepted and approved by a federal or state agency or court. Needless to say, we found that was not an appropriate approach. Our response to that position is stated in the December 2 letter by Sarah Austin, which is in your materials. I'm not going to go through a lot of detail on that, except to say that the board has since revisited its position, but because we don't have a transparent position, approach in Pennsylvania, we can't tell what the board has ultimately recommended after taking the PBA's request to reconsider it into account. We don't disclose, or the disciplinary board doesn't disclose, and a lot of the Supreme Court committees don't disclose what their last or ultimate position is if they reconsider and revisit or amend a position they've already taken. In most states, you can tell what the new position is because it's published in some fashion. Disciplinary board doesn't do that. We hope that position will change sooner or later with the new additional members, relatively new additional members to our Supreme Court. By the way, in New Jersey, for those of you admitted in New Jersey, the New Jersey State Bar, under the direction of Tom Kroll, who is, of course, their first openly gay president, recommended that the model rule approach be approved by the New Jersey Supreme Court. And I spoke with him the other day. I said, well, have you heard anything recently about adoption of Rule 8.4G in New Jersey? And he said, well, all we've heard is crickets. There's been no action taken by the Supreme Court, notwithstanding the strong recommendation by the New Jersey State Bar. The other states are in various processes of pursuing this rule. There are some state bars who have already rejected the rule, like Illinois. Josh has urged a number of state bars to reject the rule. He's had some success, along with other conservative First Amendment advocates, and that's fine. I think that my personal view is some of those First Amendment concerns are either inapposite or overblown, but maybe he'll be able to convince me otherwise. Is there anything else we have here? Okay. I'm not going to go through all the various concerns of the disciplinary board notice because we hope we hope they've amended their approach to the issue. We think they have, but unfortunately, to the extent we know anything about it, we're not permitted to say anything more. I'm going to leave a couple of slides up, Josh, that kind of refer to some of the concerns that are addressed in your excellent article. So with that, I'm going to let Josh proceed.
They're fantastic. Thank you so much. I feel like the interloper because I'm not a member of the Pennsylvania Bar. I come from outside. I come from the great state of Texas, although I'm a New Yorker. I went to Penn State. I clerked for Judge Kim Gibson in the Western District of Pennsylvania in Johnstown for 2 years. So I spent a lot of my formative time in Pennsylvania. It's always a pleasure to be back here. Rule 8.4G is very important, and it does a lot of great things to promote equality in our profession, and I laud those goals. In a few spots, however, it fails to protect another equally, if not more compelling interest, which is the First Amendment. So my goal here today is actually practical. You can read my article if you want, but I have 3 concrete recommendations that I think will help this rule pass constitutional scrutiny. And actually, the Pennsylvania Bar recommendation, I think, goes actually maybe a third of the way there. So I'm actually grateful for some of the changes they made. So first off, I'd like to discuss that this rule is somewhat unprecedented. Over the past 2 decades, nearly 3 dozen jurisdictions have amended their local rule 8.4 to prohibit discrimination, harassment, and other forms of bias. But with few exceptions, these rules only govern conduct within 3 categories. That is, bias during the representation of a client or in the practice of law. Second, conduct that implicates a lawyer's fitness to practice. Third, conduct that prejudices the administration of justice. You can see the footnotes in my article. I have the 50-state survey right there. All of these standards are more closely related to conduct at the core of legal practice. By its own admission, 8.4G goes beyond that with this label, conduct related to the practice of law. So although courts have generally upheld regulation on attorney speech, as this expression becomes more attenuated from the Bar Association's traditional purposes, the state's interest becomes less compelling. Rule 8.4G applies to, quote, bar association, business, or social activities in connection with the practice of law. This would include, I think, dinners hosted by bar associations or other similar groups, maybe the Federal Society or the NAACP. These are all social activities connected with the practice of law. Further, the rule doesn't only prohibit sexual harassment, and here I think actually the Pennsylvania bar versus the Philly bar illustrates this point well. It reaches harassment, which is defined as, quote, derogatory or demeaning verbal conduct. The rule doesn't define demeaning, but take out Brian Garner's treasure, the Black's Law Dictionary, and it defines demeaning as exhibiting less respect for a person or group of people than they deserve, or causing them to feel embarrassment, ashamed, or scorn. This is fairly vague standards, and I appreciate the Pennsylvania bar is trying to put it grounded in some case law, which I think actually goes a lot of the way to cure the problems. But as drafted, 8.4G sweeps in a lot of matters of public concern, and also imposes an unlawful form of viewpoint discrimination. Now, this rule hits deep close to home. Speaking about controversial topics, I do this for a living, and I seem I come to all these cities. Imagine if a bar association held a CLE on a range of topics, which I'll give you. By my reading, each of these topics could give rise to a bar complaint. So let's say there's a debate on affirmative action, and a speaker discusses mismatch theory, and contends that race-based affirmative action should be banned because it hurts minority students by placing them in education settings where they have a lower chance of success. Justice Scalia made comments like this during oral arguments a couple years ago, and a lot of people found them quite demeaning. But there's a fairly large body of scholarship on mismatch theory. Could I reasonably know this will give rise to a bar complaint? Probably, depending on the audience. Or gender. What if I argue at a debate that women should not be eligible for combat duty? Will some women find it demeaning? Probably. What if I argue that the speaker or the owner of a for-profit corporation can exempt female employees from receiving birth control, right? This is litigation going on. Do people find that embarrassing towards women? Maybe, I don't know. Ethnicity, right? If I say that core Matsu, right, the anti-canon was correctly decided, and that in times of war, the president should be able to exclude people based on ethnicity, when people of Japanese descent find that demeaning? Probably. I can go down the list: disability, age, sexual orientation, gender identity, marital status. I can go down the list. The reason why this rule runs into problems is that it sweeps in speech on matters of public concern, and nothing in the rule itself excludes that. And this wouldn't only apply to me as a speaker up at the podium with colleagues at the microphone. It would apply to dinner table conversation, or conversation at a Phillies game, or whatever it happens to arise. Now, I think that the rule as drafted probably survives what's called a facial challenge in the First Amendment. It's tough to invalidate something on its face here. But I think there are a lot of individual challenges. So the question here isn't, should this be facially struck down? I think there's one part that I'll get there later. But as a whole, I think it's probably okay. But do you want to implement a rule that puts a lot of lawyers' licenses on the line by engaging what I thought is protected speech? Okay? Now, there's one part of the rule that I think is very problematic, and it was mentioned earlier before. The comment 8.4G provides that, quote, lawyers may engage in conduct undertaken to promote diversity and inclusion without violating this rule by, for example, implementing initiatives aimed at recruiting, hiring, retaining, and advancing diverse employees, or sponsoring diverse law student organizations. Now, why was this provision added? Because a lot of what lawyers do involves diversity initiatives, and perhaps someone could find that demeaning. So there's an expressive carve-out for activities used to promote diversity training, diversity hiring, etc. But what if you take the opposite perspective? I mentioned mismatch before. What if you take the perspective that these efforts are detrimental to society? This is an express viewpoint discrimination. It sanctions one side of the debate and not the other. At a minimum, this comment needs to be cut, because this is where you get invalidated. And with overbreadth, you may get the rest of it tossed in. So that's my public service. If you want things to survive, cut out the viewpoint discrimination. I'm serious. If you guys lose, this is where you lose. This is it. You mark my words at this 1:07 p.m. But more problematic, I think it's emblematic of a general trend. The sorts of speech that will be affected by this disproportionately are on the right side of the ideological spectrum. It's inevitable. I speak here in self-interest. Speech supporting a right to same-sex marriage will not be considered derogatory. Speech criticizing it will. Speech supporting an interpretation of Title IX that permits bathroom assignments based on gender identity will not be considered demeaning. Speech critiquing it will. Speech opposing immigration policy that excludes people based on their nationality will not be considered discriminatory. Speech endorsing it will. A range of theories very well can be silenced under the threat of unconstitutionally vague standards of harassment. Experiences of political correctness and speech codes at college campuses, my world, provide a roadmap of the sorts of speech that complaints might be filed under Rule 8.4G. But we are not beyond hope. I think this rule can be salvaged, and I do think there are significant steps that can be taken. So first off, I applaud the Pennsylvania Bar. This reasonably knows standard, I think, is a mistake. It's, as you said, a negligent standard. I don't know what a reasonable person's standard is anymore in 2017. I've given up trying to figure it out. But when my law license is on the line, at least impute knowledge. And I know by saying this, I will have the specific impacts. I think that mens rea reform, to use the phrase of the day, right, is actually a good start. Also, the PA Bar added an underlying portion that said, it's misconduct to engage in conduct that the lawyer knows is harassment or discrimination, as those terms are defined in applicable federal, state, or local statutes or ordinances. I think this is also actually a very good move, because harassment by itself isn't a common phrase we come across. So you have sexual harassment, there's a lot of case law on that. And you have harassment in terms of a hostile workplace environment. We know about that also. What is just harassment by itself? This is not a common legal term. So by connecting it to a body of case law, right, I think that actually, and I think that's why the Philadelphia Bar perhaps opposes it, makes it a little bit less nebulous, but also makes it harder to bring such complaints. I have an additional friendly amendment to that. Add a requirement of severe and pervasive. So any employment lawyers in the room know that one of the hardest elements of making out these harassment claims is whether it's severe or pervasive, right? It's possible that a single offhand comment could give rise to a Title VII complaint, but it's very hard to prove that. More likely than not, you need a lot, you need something that's really bad or a train of conduct to get you there. Because this is a core speech issue, I think a single remark should not give rise to a bar complaint. If it amounts to something that's severe and pervasive, that is egregious as the case law defines it, I'm okay with that. But I would add a suggestion that this is a will, not a may guide, that you have to show severity and pervasiveness, okay? My second recommendation is to just cut that line about the viewpoint discrimination, the promoting diversity. That's just a straight up viewpoint discrimination. Unless you want the entire thing to be invalidated over breath, just cut that out. I'm giving you public service. I'm trying to be helpful here. I'm a tired gut, right? Third, if you go back to the legislative history, so to speak, of the provision, before the final rules developed, there were a lot of things that were cut out. I think something was mentioned before, mens rea. They originally had a strict liability. They made it, negligence. Another line that was cut out, this was in the 2015 draft, said that the attorney's, quote, private sphere of conduct is protected. And it said that this rule does not apply to, quote, speech on matters of public concern. I would go out of my way to stress that in a comment, that speech on matters of public concern are not the subject of liability. If I'm wrong, if my concerns are overblown, there's no cost of doing that, right? If this is not about going after speakers, talking about traditional marriage or bakers or butchers or candlestick makers, whatever, right? Then put it in the comment, right? Say this does not apply to matters of public concern. Bring back the December 2015 comment. I think that would actually go a long way to assuaging my concerns. Now, I'll finish where I think my colleagues also finished, which was on the disciplinary committee, and two ships passing the night. I think they, and I don't know any people on this committee, but I think they recognize part of the difficulty of implementing this rule. Because if someone knows or reasonably should know that this will be offensive, this will give rise to a lot of bar complaints. And there will be some serious ones. I think the comment was mentioned earlier about calling you a poor reporter because you're a female. I mean, the honey, these dear darling. That's bad, and I think you can get that into a sexual harassment law. So long as you make it clear in the rule itself that this is not going after speakers on matters of public concern. If you read the history of this rule in the ABA delegation, the House, and everything else, they took stuff out that protected speech. There was language protecting speech; it was removed, and I think it was removed deliberately. It wasn't like a Scrivener's error. Now I don't think there were improper motives, but I think they wanted to make it that it was a little bit easier to bring a claim than it should. But when you're dealing with free speech, that is the highest compelling interest we have. And the bar's interest, I think, is more centralized. The practice of law, the administration of justice, the lawyer's fitness. As you get more attenuated from that, you start digging into a lawyer's personal sphere. And the philosophy of, well, let's trust the disciplinary committee. If your law license is on the line, right, and you have to spend your own time and effort defending this for years, and you lose clients in business, it's not very reassuring to say, trust me, right? That's not how the First Amendment generally works. With the First Amendment, the burden's on the government and not you. These disciplinary proceedings put the burden on you to defend yourself, that you didn't actually know you would offend people and demean people. My God, I don't want that hearing. I'm going to lose that hearing, right? I know when I say certain things, I will offend people. My God, I'm on Twitter, right? I tweet sometimes knowing people get a rise out of it, right? That's part of our world. And sometimes people use conduct to offend people to get their attention. Fuck the draft. Burning a draft card, right? These are acts people engage in to get people riled up for the purpose of persuading them. And if these sorts of acts now give rise to professional misconduct, I think this rule runs too far into the First Amendment. Now, who will be the unlucky lawyer who's the test case? I don't know who this person will be. But there will be a test case. A number of states have declined to adopt it. I've written a couple letters. It was mentioned earlier. Urging states not to adopt it. I don't think I've been successful. I don't think I've read any of my stuff. But I've written a couple letters to state bars. Nevada did adopt a few others. I think, was it New Hampshire or Vermont? I want to say
Vermont.
Thank you, yes, thank you. Vermont adopted it quietly. So as non-transparent as Pennsylvania is, Vermont was even less transparent. So I appreciate that you're having these public events. We're speaking here today. We're going to talk to some judges after this with the Same Dog and Pony Show. But I am very grateful. I will stop here. I welcome your questions, and I thank you again for your attention.
So what I want to do is, first of all, give the panelists an opportunity to respond to each other. Pardon me, failing that, I have a couple of questions for them. Then give you an opportunity, and then if we still have time, Tom has created some scenarios for us to work through. So, Doris, we can start with you if you've got something you want to
I'm going to
rattle
wait
the crowd with.
to jump into the fray when the fray happens.
When the fray happens.
So I one comment to what Josh said is, so I think you mentioned that a single remark shouldn't be enough to spark a hearing or spark a complaint. But I think that's that the threat of that is what the rule is designed to do. The fact that you need to think about things before you say them, and we as lawyers need to be cognizant of what we say and how it impacts others. And I think that the rule is designed to dissuade this type of language and conduct. And if we say, well, it's only going to be if it's severe and pervasive, well, then what becomes severe and pervasive? And who's to say what somebody says to one person isn't going to be considered severe and pervasive to that person versus somebody else?
Well, I guess my reaction would be that lawyers should be taking the lead in this area and not being dragged kicking and screaming to the forefront. I have a young lawyer daughter. I wouldn't want her to be subjected to just one instance of severe harassment, let alone pervasive or long-term harassment or discrimination. I would hope that there are circumstances where just one serious instance could give rise to a legitimate disciplinary complaint. It shouldn't have to happen over a longer period of time. I think that, we rely upon our disciplinary counsel to exercise discretion on a daily basis. Occasionally they make mistakes. I mean, I've defended lawyers successfully against what I've felt were inappropriate efforts to silence lawyers in the disciplinary context, especially lawyers who may also be active in politics. And, the First Amendment free speech rights should supersede, and I think would supersede an application of this rule, especially if it's over something that is a politically sensitive issue as opposed to what we would all might recognize as true harassment or discrimination. It's I think more like what was it, Justice Stewart in the pornography context? You know it or you see it when you know it when you see it, and I think that ought to be part of the analysis here. So I think that it's an opportunity for us to show that we take these matters seriously. If you focus on the cases, you don't have to go very long to find instances of severe misconduct by lawyers, including instances of sexual harassment. There are many instances where lawyers demand sex from clients as a quid pro quo to provide legal services. That was one reason why we gave rise to the rule prohibiting initiating intimate relationships with existing clients, but that's been a constant problem, particularly in the family law area, for decades. And the existing rules really are very blunt instruments to try to deal with this issue. There really aren't any rules that at least in Pennsylvania, for example, where we didn't even adopt a comment to Rule 8.4, which was mentioned earlier, there really aren't any rules to deal with this except for civility-style rules, and as you all know, in Pennsylvania, our civility rules are not enforceable because they are merely aspirational in nature. They're not mandatory in nature as many other states are. So I think it's a wise step forward, especially taking into account the clarifications and tweaks that we've suggested.
And it's interesting that this all sort of happened to balloon right after we had a whole scandal with our own Supreme Court and pornography and derogatory comments made by justices of our own Supreme Court. So, we need to hold everyone in the profession to the highest standards, even our Supreme Court justices. And if there's no formal method to even bring that concern, then I think needs to be something done.
So if I may, the standard is severe or pervasive. It's or, not and. So pervasive means ongoing. Severe can be a single act that's really egregious. So it would sweep in a single egregious act. So it's severe or pervasive. So I think that's one concern. The second concern is, I appreciate your candor. You're trying to dissuade people from saying things. That's 100% what this rule is trying to do. That's called chilling speech. And Justice Potter Stewart's test, when you see it, for obscenity is no longer good law, for good reason. We now get strict scrutiny to speech restriction. We haven't had that standard in half a century. And when you have content-based restrictions, right? So what's a violent video game, right? You might know what a violent video game is. You might know what it is. But all the justice in the court said that's unconstitutionally vague, right? What's a violent video game in Brown v. MA, right? What's demeaning speech for a trademark? The Slants, right? If I want to make a rock band named the Slants, which is the takeoff of the Asian American eye, right? The Slants, right? Is that demeaning? Yeah. 9-0. I'm sorry, 8-0. All the justices agree the government can't pick out what demeaning speech is. I don't think the government can decide what demeaning speech is. I don't think it can decide what harassing speech is by itself, unless it's in the context of case law, which means severe or pervasive. So if you stick with this harassing standard without any sort of grounding to cases, you're running to a facial challenge. With this thing, I think you survive, with the PA recommendation, I think you survive a facial challenge, but you lose as applied.
I'd like to ask you a question, and I understand your concerns with sort of the general scope of the rule is including more than the severe. I'm struggling, having practiced or been around, kicking around the law for as long as I have, with the scope. And you had some concerns with the scope, and I don't want this to be just pick on Josh.
It's okay. I'm used to it.
Well, but I share your First Amendment, background, although I've got more. willingness to find accommodations. But my concern is in your saying, well, you really have to limit it to representing a client, appearing before a court. So much happens in what we do in other places, and I will share a conversation I had last night with a young lawyer who said, and this is what I heard, as part of this big trial and, war room and all this stuff. We weren't in a deposition, we weren't in any formal legal context, but it was the gang who had gone through this experience that everybody knows a trial is. And the comments were not, I don't think, probably severe, but were disrespectful, discriminatory, harassing, demeaning. And that young former student said, it just didn't make me feel like this was a welcoming profession. How do we deal with that? And as Tom says, how do we as lawyers who want to take the lead and say, we should behave, we shouldn't be trailing along saying, make me, but how do we deal with that larger issue? Women have struggled with this, and I don't mean to be the feminist on the horse, because I believe most of the stories are about gender discrimination, and I think that is probably not the most serious. I think the most serious had to do with ethnic and racial and religious discrimination. But how do we deal with what we dealt with in 1981 when the Union League was an all-male club, understanding the right to, you should be able to get together with folks that are like you, but that's where the deals were made. And that's where the partners found the associates that they were going to champion, and a bunch of us had to go in the side door if we were admitted at all, and certainly couldn't go in the locker room. How do you, with your restrictions, how do you deal with the larger impact and the fact that more of the law happens outside than in a formal context?
Thank you. So I'll answer this in two ways. So first, my third recommendation was to add a comment saying this is not concerned matters of public concern. If you added that, that would probably remove 50% of my troubles. If you make it clear there's not anything that's public concern, but perhaps the inappropriate comments here at a dinner after a trial, I think that would go a long way. I'll answer the question more broadly. I don't think this rule will change hearts and minds. It doesn't. It won't. It will punish people for sure, but it won't change hearts and minds. If the goal here is simply just punish and dissuade people from speaking, I don't think that will suddenly make people say, you know what, I shouldn't think about women or minorities or whatever else. It's punitive. Now the bar, I think, does have a role in punishing certain types of conduct within certain spheres. But I don't think that extends to the private spheres of an attorney. I mentioned this in my paper, I didn't talk about it before, but I think there are certain, under state constitutional law, non-delegation problems. How far does the bar's disciplinary authority even extend? Can the bar even discipline someone for a comment made at a dinner? Now, I know they can pass the rule, but does the bar have that authority? I don't profess any expertise in Pennsylvania jurisdiction, but I can imagine someone saying this is simply beyond what the bar can do. And the reason why I led off my presentation by doing the 50-state survey is that no state's ever tried this before. Vermont, I guess, was the first one to try it, and they made it without any suggestion, no revisions at all. But if the rule is just we're going to regulate all aspects of an attorney's life, because let's face it, attorney is your job, is your life, right? Virtually everything you do is your career in all aspects of what you do. As the bar reaches its hand further, you need more narrow tailoring to get there. So if we're talking about comments made at a deposition, I think a single bad comment at a deposition is more easily punishable than a similarly bad comment made at a baseball game, right? The nexus of where the bar's disciplinary authority, I think, significantly matters here. So to answer your question, I think if you limit it to matters of public concern, that will probably take care of half my concerns. But more precisely, these sorts of rules, I don't know how effective they are. I think they're punitive and perhaps go beyond the bar's authority altogether.
I want to just respond to you in one way, because I couldn't agree with you more, that you are unlikely to change some folks' hearts and minds. I think that the ER docs got that long ago. You triage. There's no way. Regardless of me, you're going to be fine. This is where I'm going to concentrate my efforts because these are the people who I can change. I don't see necessarily the goal of this as being changing hearts and minds of people whose minds and hearts are already where they're going to stay. I see this more as saying, we as lawyers say, and this goes back to what Tom said, we as lawyers say we should model appropriate behavior. We should be the ones that say this is what the standard should look like and this is what we should live up to. And if someone secretly in his heart thinks I shouldn't be practicing law and certainly shouldn't be molding new minds, I'm not going to change that. But we as a bar can say, but that's not something we're going to endorse. And I think that's what this is designed to do, is say this is what, I'm not saying it's aspirational because that was the old ECs. They're aspirational. We don't know what the hell to do with the ECs. They were there, we couldn't enforce them. This is aspirational in that it's the bar saying we need to do better. And the judiciary has done it. And extending it beyond the obvious to me, and I struggle with some of the things you suggest, but extending it beyond the deposition in the courtroom to me is crucial to it having any effect, the effect we want it to have. And I don't think the effect we want it to have is chilling speech, as that term is used. That's a missile term, I know what you mean. It is directed at conduct, but that conduct is expressive conduct. I get that, I get that. And I'm not going to argue with a con law teacher on that, although,
You're welcome to.
No, that's okay, Josh. We got plenty else to argue about.
And just to pick that up, I mean, when Professor Chanenson mentioned my biography, you all heard I'm very active with the Bar Association, both Philly Bar and statewide. To limit the effect to what I do in a courtroom or in a deposition or in my own firm only catches about half of what my real professional life is, maybe a little bit more than that. But for those of us who are out there trying to get clients, who are trying to improve the profession as a whole by bar association activity and other conduct that's professional in nature, I don't think we should limit the application of this law to only what happens within the walls of our law firms and what happens in depositions and in courtrooms, because our professionals is much broader than that. The other point I wanted to make is that as far as changing hearts and minds, I agree we're not going to change the hearts and minds, but I think this rule also has to be considered in connection with another resolution recommendation that was just passed. So 8.4 passed at the November 2016 Pennsylvania Bar House of Delegates. At the May 2017 meeting, the Pennsylvania Bar, under a resolution recommendation that the women in the profession also put forward in connection with the Minority Bar Committee, the Diversity Law Team, the Philadelphia Bar Association, the Allegheny County Bar Association, and in consultation with some representatives of the PACLE board, was a recommendation to make it a mandatory requirement that 1 credit every 2 years be devoted to bias elimination, diversity, inclusion training. So if we see these two recommendations in a connected way, it's an effort to take a step forward and to educate ourselves in addition to what would be required of the conduct.
I would only note that under the current rules, there are limitations on your free speech rights. You can't go out and accuse a judge of being corrupt. You can't, or taking money under the table, prohibited by Rule 8.2. There's something you can't, make egregious statements to a witness who you don't represent, or give legal advice to a witness you don't represent. There are limitations under the current rules. The current rules don't say anything about political speech, but I've never heard of anyone prosecuted for engaging in political speech while harassing a witness. And judges have been much more willing to sanction lawyers for misconduct in the courtroom, in other settings, including particularly in deposition settings, for harassing younger women, demeaning younger women, harassing on the basis of race. A lot of such instances. Judges were a lot more reluctant to do that 20 or 30 years ago, but they're not reluctant to do it all, particularly federal judges. A lot of such sanctions imposed, and they can be required to go to training like this, as well as getting the monetary sanctions and perhaps other more severe sanctions. So it's certainly the judges get it now for the most part. I think it's time that the profession gets it as well.
You know, useful, if you walk through Rule 8.4, I think he mentions a lot. There are a number of prohibitions that do restrict speech. So 8.4b says misconduct to commit a criminal act reflecting adversity in a lawyer's honesty, trustworthy, fitness to practice law. 8.4c, you can engage in dishonesty, fraud, or deceit. 8.4d is about conduct prejudicial to the administration of justice. 8.4f is about assisting a judge in violation of rules of ethics, etc. All those rules are in the courtroom, deposition, etc. They're tied, there's a close nexus to the practice of law. Where 8.4g departs, it goes to conduct related to the practice of law. That's the new one, right? If you're engaging in speech in something within the core of your profession, that can be regulated to the hilt. It's when you go beyond that, when you're attenuated, where is the state's interest there?
So let me first say, Tom, you said that in response to bad behavior in depositions, people could be sentenced to come here. I hope this isn't viewed as a punishment for all.
It's the purgatory equivalent.
No need to self-identify. Let me ask a question and ask the group to analyze the rule for me. Really going off of your fact pattern that you mentioned when you were in the deposition recently. You were referred to as the court reporter twice. In Vermont, would that have violated Rule 8.4G? And I'm not saying that you have to answer it, but just to the group as a whole.
I don't think so. Not in Vermont.
Well, under the rule, I think.
Well, I mean under the rule, because
Well,
I thought Vermont has adopted the rule. So under the model rule as adopted by the ABA,
Okay.
does that behavior violate new Rule 8.4G?
I think it could, if the person intended it to be demeaning towards me. If the person said it negligently, probably not, which is, in candor, I believe it wasn't a litigation tactic, although it may have been because there were other things that happened within the course of this case that lead me to believe there may have been. So I think it needs to be, all of the circumstances surrounding need to be examined to be able to determine whether or not it was a violation or not.
So part of it's going to be the mental state, right?
Yeah.
I'm sorry,
Well,
Josh, did I cut you off?
It is, right? Let's walk through the rule. It's misconduct to engage in conduct the lawyer knows or reasonably should know is harassment, right? Conduct related to the law includes practicing law, that's fine. If harassment means demeaning activities to try and diminish a person's worth, you told us how you felt, and I agree. I think that was a sincere feeling. If you should know that by calling a random woman in the group court reporter when she's not actually a court reporter, that could give rise to conduct, and I think that's probably what would give rise to it. And whether you file a bar complaint or not, that's a different story, but it's sanctionable, I think.
And is it sanctionable under the PBA and Allegheny bar approach?
No.
Or this is all about reasonably should know?
Yeah.
Unless you had some direct evidence where you get access to the person's diary. Today, dear diary, I'm going to intentionally harass and demean any women in the deposition with me.
Or I know she's a lawyer, a rising star, and I know exactly who she is, and I go in to set the stage.
Right.
Knock her down a peg.
Knock her down a peg. I mean, I could see that.
Yeah.
So when the Philly bar decided to diverge from the views of the PA bar and Allegheny, was there a debate about what additional behavior would be swept in by reasonably should know? And recount for us that conversation and how the Philly Bar came out the way it did.
So there actually wasn't, because that wasn't the issue that the Philly Bar took with the Pennsylvania Bar's modification. The issue that the Philly Bar took was the tethering to state, local, or federal law. So I don't think the Philly Bar necessarily would be opposed to a knowing mens rea element. That was never really debated. The debate was, should we join in the Pennsylvania Bar recommendation because of this tethering requirement? So.
And changing topics a little bit, Josh talked about the comment about behavior that is designed to increase diversity is exempted from the rule. Do you agree with his view that that's in there because the drafters of the comment believe that it would otherwise be swept in under the rule, that it's behavior that is otherwise problematic, but it's okay because it's for a purpose that we like?
Right, I mean, they didn't want law firms or lawyers to be under the misimpression that they were enacting a rule that would discourage bringing minorities or others along in the profession, either through programming or through systems or summer associate systems, to say, look, we want to have a diversity program. We want to ensure that we're funding lawyers of color or some other minority in where we send them to programming, or whether we send them to conferences, or we're going to devote some funding to this so that they can be sure they're members of affinity bar groups. Maybe it's the Asian lawyers or the barristers or other local organizations. We're going to spend money on that. We may not necessarily spend as much money for others to join, the Irish lawyers or whatever, but we're going to spend the money on this, and that's not going to be deemed a violation subject to disciplinary action. I understand Josh's point, but it was designed to say, look, this kind of activity designed to promote diversity and inclusion it shouldn't be viewed as violative of the rule.
So there's no question that it was there for a noble purpose. I guess, though, the deeper question for me in trying to understand the new model rule is it there prophylactically for a noble purpose? We don't want somebody to be confused and therefore not engage in this good behavior in trying to diversify the profession? Or is it there as an acknowledgement that this noble purpose would violate the rule if we didn't say that it didn't?
I think they viewed it as the former, but there was a little bit of a latter going on, possibly. Look, the chair of the commission, the standing committee at the time was Miles Link, who was a great African-American law professor from Arizona, and very knowledgeable about these issues, and he played a lead role in getting that additional sentence in, and I think it was a wise addition. I don't think it necessarily increases the likelihood that a successful challenge will go forward. I just don't think that's going to happen.
Then let me ask one more question before I open it up to the crowd, and think of your questions, because otherwise you're stuck with our scenarios, and that's on you. So, exactly. My other question, one other thing that jumped out at me, and I'm just trying again to make sure that I understand it. If a judge finds that while I'm picking a jury, I have violated Batson and have in a discriminatory way, excluded jurors, why is that not necessarily a violation of 8.4? And I'm just confused about that, and it's probably a failing on my part, so just help me understand.
I think it may be. If it's done intentionally, it may well be deemed a violation.
Yep. Okay. And is there language somewhere in the rule that was trying to, again, for adoption purposes, or is that something I just misunderstood?
I think you could have if you had a successful Batson challenge, you found the the DA's internal memos somehow that said, we don't want to have blacks on this jury, and the judge became aware of it. I could see judges sending that to the disciplinary authorities for further investigation if this rule were adopted.
So as I understand the rule, though, it's saying that a finding by a judge that there was preemptory strikes were done on a
Yes.
racial basis alone won't be sufficient. But if you have the memos and so forth, it says.
If it was intentional in nature, that is, it meets the nose
Mhm.
mens rea requirement, I think it really could.
Wouldn't that violate 8.4D though, its conduct prejudicial to administration of justice? I think you get there.
It could, and I think there are such cases out there.
I don't think you
studied that carefully, but I think there are such cases involving striking of jurors that led to 8.4D discipline.
All right. So unless you folks have things you want to respond to that have gone as yet unresponded, I turn to our live audience. I'm confident you're live. You were live when you came in. Any questions? Yes, sir.
Thank you for the excellent explanations. I think I counted 4 different proposals that the Pennsylvania Supremes may consider if they choose to make any rule at all. Do any of them consider whether the rule ought to apply to lawyers that are on the roll but are in an inactive or retired or other capacity where they're not currently practicing, but they're still listed in some role that keeps them on the roll of attorneys?
I think it only applies to active attorneys that can be disciplined, still have an active license.
Right.
I think,
Because there are many rules that are ambiguous about that point, that don't make clear whether, there are some that say, this rule applies in the practice of law, but there are others that don't have that qualifier, and there are cases that have interpreted them to apply to even inactives or retireds.
Well, I mean, there are financial fraud cases out there, for example, where it commits a felony of some sort, then yes, it can have further disciplinary consequences. You could be removed. If you fail to respond to disciplinary inquiries, you could be removed for that basis. In Pennsylvania, not in every state. We had some hypos, Steve, if they're...
Sure, let's see if there are other questions, and if not, we will go to the hypos.
You've listed under the model rule race, gender, ethnicity, et cetera, et cetera, et cetera. Under the umbrella of disability, does that include those with substance use disorders and mental health issues, or should that be added?
Really good question. The disability rule, which is Rule 1.14, involves clients with a disability, not lawyers with a disability. So I'm not sure.
Wouldn't it at some level bring in the Pennsylvania rule that says, as defined by state or federal statute?
Right.
Yeah.
And
ADA or whatever.
the ADA and some other statutes will capture substance abuse and things like that.
One note, one of the grounds which we haven't talked much about is socioeconomic status. I didn't even mention it. What happens if a lawyer says, I don't want to hire more rich kids. I want people who are, authentic Philly people, right, who came from low-income families. That's now disciplinable. Socioeconomic status. This is a strange one to add. It sounds benevolent, but it can actually give rise to liability in some weird circumstances, depending how people actually employ it.
Other questions?
I have a question. Just as one of the hypos you mentioned, like starting a band with a arguably derogatory name. Just maybe this will show my naivete, but if you're starting a band, I understand that related to the practice of law is broader than depositions, courtrooms. But of social events, going to a band, going to your own rally, that's not tied to your job as a lawyer. There's no dispute with the new rule that would be completely non-sanctionable under the rule, correct?
So the case I mentioned, Mattel v. Tam, wasn't just starting a band, but also seeking a trademark registration. And the government has statutes saying we will not register a trademark that's deemed disparaging. And the Supreme Court basically unanimously agreed that the term disparaging is too vague, and because there are not enough standards, they struck it down. The point here is the phrase in the statute is harassment, which is defined as demeaning. demeaning doesn't have any meaning in our law unless you go to the federal and state law, which I think that's a good move in Pennsylvania to give it some grounding. But the word demeaning by itself is void for vagueness and would not provide a basis which a reasonable lawyer would know, is this going to be demeaning? How am I supposed to know?
No, sure, I understand. Maybe, sorry, my question was poorly worded, but I guess my point is like, there's still, even if there's the argument it's vague, there's still a personal sphere that is completely separate from related to the practice of law. So not citing a case, but like if you want to go to a KKK rally or some rally that is viewpoint discriminatory, that's on your own and that's not going to be sanctioned under this rule, correct? Like there's no just...
Unless you take a client.
Well, let me
Like I don't
take that.
Marketing.
What if over a bar dinner, you know what, I really love this group, the Slants. They're awesome. As a lawyer, I'm talking about the Phillies game. And so it says, I find it demeaning you're talking about the Slants. Then that could actually give rise to liability. Someone would say, I find it offensive. Or the football team in Washington, D.C., right? What if the Eagles are playing that football team in Washington, D.C.? And the name of the team was, I can say the Redskins, right? Can I say that?
The rule isn't in effect, you can say.
No, I'm not out of Pennsylvania bar, so I'm fine. But right, if you have an Eagles Redskins game, right, and you have a firm T-shirt that says Eagles versus Redskins, right, and something like that, and someone finds it demeaning, right? Is that good now, right? Maybe they shouldn't have the T-shirt at all. I don't know. Maybe that's the answer.
Get disciplined, you'll just get beer poured down your neck.
But no, I think your question is yes, there still is
yes.
a personal sphere. It's very easy, I think, is the argument that Josh is making for that personal sphere to blend into your work sphere. It could encourage lawyers to get to know non-lawyers. So then there's a better opportunity to separate your two worlds. But I don't think there's disagreement that there is, however broad this rule may be, there's a limit to it. All right, there is still something related to the conduct of the profession.
Thank you.
So, Tom, do you want to actually talk about a couple of those cases that you have slides on, and then we can go to the scenarios, or you can skip over them?
Briefly,
in your hands.
The first scenario is the so-called love muffin case. I love this case. It's just decided last year in New Jersey. I love muffins, but this is a case where a lawyer kept sending harassing email to a former female employee of the firm, even after she told him to stop, and used all kinds of phrases, love doll, love kitten, and so on and so forth. Plus he lied during interviews with the disciplinary authorities when he was asked about it, and he used a municipal email address so that all those emails could be recaptured, so that didn't help his situation. But the New Jersey rule currently is very limited. It only has conduct involving discrimination, where the conduct is intended or likely to cause harm. He was disciplined with a censure, which is a material level of discipline. So there are cases out there, even under the existing rules, as earlier mentioned, there are 25 states that have some sort of black letter or comment rule language. Also, just last month in Michigan, a lawyer was reprimanded for referring to a woman who's a probation officer as an angry black woman. That's why you don't have a husband. They just kept going at it all the way into the hallway and then into the courtroom. And making it more interesting, the lawyer who was making these remarks was also black. He was reprimanded in the middle of last month for engaging in discourteous conduct. Michigan has a Rule 6.5a, which requires all lawyers to treat people with courtesy and respect when involved in the legal process, and have to take special care to avoid acting discourteously or respectfully because of the person's race, gender, or other protected personal characteristic. So that's a pared down version of what Model 8.4G is all about. A very interesting issue in my view, and query whether it would necessarily be deemed to violate Rule 8.4G. I'm sure you think it would.
Okay.
I do.
Another, yes.
Can I ask you a question of Professor Blackman? I'm assuming it's Professor Blackman.
Call me Josh, is fine.
Would you find, in the previous example, would you find that statement or those statements to be arguably protected speech?
So the interplay between harassment and the First Amendment is tricky. I encourage you to read an article by Eugene Volokh. There is an argument that most workplace harassment laws are unconstitutional. I'm not making that here. So under prevailing employment law, this could be sanctioned, because I think it would be severe. It would rise that level. But as a matter of first principles, my professorial tone, I think it's a good argument that most workplace harassment laws are unconstitutional. They're vague. They're content-based restrictions or viewpoint discrimination. If you read the Slants case, right, Mattel v. Tam, go back to Texas v. Johnson. Offensive speech is protected, right? True threats cannot be. So let's just, a mini common lesson, right? We had RIV versus St. Paul, which involved a cross burning. But the mens rea requirement was one of negligence, right? If you basically didn't have an intent to threaten. And the court struck that down on varied grounds. Then you have Virginia versus Black some years later. When you burn a cross with the intent to intimidate or threaten, that makes it a crime. So I think it does go to mens rea. So if you make these remarks as a threatening matter, I think you can probably punish it. Short of threatening just to piss someone off, probably is protected, but not under current law. Thank you. Thank God I'm not a judge, right? Do not let professors become judges. It's a bad idea. Just keep them off the bench. And at the White House also.
So also very recently, in Colorado, a lawyer admitted misconduct was in violation of their version of Rule 8.4G. It's not the model rule. During remarks in a conversation with the mother and her 15-year-old child, it was a guardianship style proceeding. The mother calls the lawyer and says, "You really got to help me deal with this unruly child," and asked him to put him on the speakerphone. And during that course of that conversation, the lawyer said, "Well, look, if he doesn't want to be placed in foster care, he better start behaving." And then there's a couple more sentences, and he says to the boy, "You're behaving like some kid out of the ghetto." And mother complained about it. Lawyer was sanctioned, public censure, which is of course public, both under 8.4G and their Rule 4.4A, which says you cannot use means that have no substantial purpose other than embarrass, delay, or burden the person. Well, the lawyer there trying to be helpful, he thinks, apparently, but obviously was disciplined for it. I think this is very interesting, maybe a close question. Some people have reacted and said, look, what would happen if it was under Model Rule 8.4G? Do you have a view, Jen, how we should react to this one?
Well, I think either with the reasonable knowing standard or with the knowing standard, I think it would be violative of the rule, because you've got to think that if somebody says you're acting like you're kidding ghetto, I mean, that's offensive to any number of protected classes. As a Jewish woman, it affects me as a German ghetto, other minorities and other protected classes. I think it's reasonably calculated that it would lead to that belief and the meaning of a particular person. And it was also certainly in the conduct of law, even by a more limited definition. So
yeah, you don't need 8.4 to get there. I think you can do it under pre-existing rules.
All right, let's turn then to the first of these scenarios. Tom, do you mind taking it?
We vetted these scenarios. We had about 20 of them, and people like Sarah Kelly, who's a well-regarded employment lawyer at this firm, worked through many of them with us. Assume you have a managing partner of a firm. He's fully aware of various invitations at firm-sponsored social events, some of which are singularly gender-based. Has the managing partner committed some kind of discrimination under the rule? Is there any potential violation of the supervisory lawyer rule, which is Rule 5.1? I think this gets into Josh's concerns about the caveat concerning supporting programming that the law firm may provide to encourage diversity and inclusion. Any reaction to whether this is...
So you said singularly gender-based. Does it include women-only conferences?
Yeah,
or
I
men only,
mean,
or either way?
typically women only.
Could a man find this disparaging? I mean, don't forget, most Title IX complaints found nowadays are actually by men who complain that the schools engage in witch hunts against them. So I think men can start filing bar complaints against female-only events. That's why this carve-out was put there, to allow diversity events to proceed unimpeded.
But I think it's important that when you're planning these types of events, for instance, the Women in the Profession Committee of the Philly Bar and of the PBA, our events aren't exclusive to women. I mean, if men want to attend, you're more than welcome. So I think that's the critical element in this. If it's to the exclusion of one sex or the other, then I think yes. But I think you can still have programming that's geared to a certain class of people, but as long as it's not exclusive of others, then you're okay.
Last one?
At least this one, we need to go a couple minutes after 2 to give you your full 2 hours. We started late. Oh, come on.
Sorry.
Just a few minutes. You were long in the lunch line. Let's be candid.
He's the hallmark.
Sorry.
Okay, assume you have a male major rainmaker, devoted evangelist, who practices what he preaches, makes no claims, he'll never give any assignment to an associate who's LGBT, even if that associate has the right experience. It will be of the best value to the assignment and to the client. Has the rainmaker committed prohibited discrimination? Would be subject to Rule 8.4G. Yes, easy, right?
Yeah, I mean, I think
Easy?
that's me.
Okay, easy.
What if the client then was, what if
This
the
is
same lawyer refused to represent a client based on their status? It sounds like the distinction between...
The rule doesn't apply to taking on clients. There's express carve out there for that reason.
Right.
Yeah, and some people may take issue with that
There
in the same way as the Masterpiece Bake Shop.
There's a question over there. Yes.
Another twist, what if the client
Yeah.
refuses to have the LGTB associate work on the case?
We sanction
This
clients.
is those of us who
Well,
taught
what is the
professional
lawyer's
responsibility,
responsibility?
yeah.
What is the lawyer's responsibility in that scenario?
And there have been, and certainly when we were young associates together, Texas, by the way, it was Texas. Well, Texas, we're not sure we want a New York Jewish woman in front of a jury in Texas. It's not you. It's a New York Jewish woman in front of a Texas jury. And the dilemma for the lawyer is best interest of the client.
Right.
And
I think it's still like that, actually.
well, but and the answer, and the Supreme Court gave an answer to this in a custody case where a mother remarried, mixed marriage in, I think it was the 60s, but a mixed marriage, and the state said, it's not that we think there's anything wrong with mixed marriage, and it's not that we think there's anything wrong with the black father, it's just that we know this community will not accept that, and that will be really hard for the kid, not in the best interest of the child. And the Supreme Court said best interest of the child is really important, but racial discrimination trumps that, and no, we're not going to permit this to be a reason. So I've always struggled with that one, because we are supposed to promote the best interest of the client, but if the client says, Texas jury, and it's not the same anymore, this was 1982, Texas jury is not going to really relate, they're going to hate a Jewish woman from New York standing up in front of the jury. That was actually said. That's an actual, this is what the client is concerned about. I think we as lawyers have to say, we got it, I'm sorry, this one trumps.
In the 1970s, Justice Ginsburg, then Ruth Bader Ginsburg, argued from the Supreme Court, Justice Blackman, a relation would always rate the advocates. His annotation for Ruth Bader Ginsburg was NYJ, New York Jew. Supreme Court, the benighted Harry Blackman, yeah, he gave her a C or a D. He actually graded all the advocates. He didn't think she was very good. Oh, I just really over Blackman, yeah. True.
Someone
So
else
it's there,
have a
trust me.
question all the way back? The same question. All right, let's turn to scenario 3 and then we'll release
Okay,
the class.
this will be the last one. Male partner attends Phillies games with associates, occasionally takes associates to the games with clients, prospective clients. His spouse insists that he not invite any young female associates to these games, and he follows her direction. Well, yes. And there's concern that, you adopt these rules, well, you're going to encourage, situations where older lawyers will not even interact with younger lawyers of a different sex. There's concerns in the coaching scenarios, older male coaches dealing with young female trainees. Is it a wise thing to do? Do you have to have other people around you to be sure that you have witnesses? I mean, it's really an unfortunate development. But here, it's clearly a discriminatory act. You're not allowing a woman to participate in a marketing event. Our employment lawyer says it's violative of current employment laws. If there are any employment lawyers who think differently, let us know.
So what I'd like to do, and if you go to the very last slide with the contact information.
So they can harass me later. No, just
Yes,
kidding.
exactly.
That's what they
Yeah,
do.
we can find you. So
You can't demean me, I'm immune.
what's interesting to me, among other things about this, is how long it has taken the Pennsylvania D Board to decide what they're going to do publicly, and then the Supreme Court to decide what it is going to do. The comment period for the rule has long since closed, yet we are still waiting and waiting.
We were afraid when we put this together that.
Well,
we'd be
right.
mooted.
Well, at first, we wanted to be able to talk about the new rule, and we said certainly by November. Well, not so much. But I will say this, and I actually think it's a positive thing. The only information we could get out of the D Board when we called was that they have never had a rule that has precipitated so much comment from the general public and the practicing bar. So this is something that our colleagues are paying attention to. What happens, stay tuned to this space. Stay tuned to the wise sayings of those 4 people. Again, I want to thank Cozen O'Connor for hosting us, and thank all of you for coming. There should be a spot on your way out, yes, Ms. Martin, for their CLE form. You can leave your CLE form where it is, and it will be processed. This takes a few weeks, but the law school will process it for you. Thanks very much.
Oh, thank you so much. We was all over again a couple hours. Thank you, sir. Yeah, I once walked into the. Yep.
Yeah, my column.
Like Naked Gun, right?
My column.